Hi, and welcome back to the Business Career College video series. In this video, we're going to have part one of a five-part series. And this five-part series is going to cover the ethics and professional responsibility credit. Now, it depends what jurisdiction you're in. So some folks need an ethics credit. Some folks need a professional responsibility credit. This course, you'll hopefully know in advance of taking it, will be approved for whatever ethics and professional responsibility credits you happen to require. This case, unlike we have one prior ethics and responsibility credit, that's the addressing conflicts of interest. This case is actually based on two case studies. And what I've endeavored to do with these case studies is to draw up case studies that are roughly representative of reality. Hopefully these are cases that people who are participating in this class could see themselves actually being involved in. I find sometimes with ethics case studies, we end up with these very black and white scenarios where it's hard to envision yourself in a particular scenario. So I've really tried to work around that here. Now, as always with any course of this nature, we have our legal disclaimer. So once you're watching this, it means it will have been approved by the Financial Planning Standards Council. And that approval by the Financial Planning Standards Council, of course, does not mean that anything that you see here or that I say here would reflect the views of the Financial Planning Standards Council, or for that matter, any other entity who may have somehow given some sort of acknowledgement to this course. So the views and content within are entirely those of myself, Jason Watt, an employee at Business Career College. So we are going to work through two different scenarios here. And the two different scenarios, the first we're going to look, for each scenario we're going to look at the dilemma, that is, what's actually gone wrong. We're going to look at some of the choices that are available, and then we're going to look at some of the guidance that might be available in order to give us a push in the right direction. Now, as we work through the cases, and we're going to get to them in the next video, but as we work through the cases, I do want you to think about how you would handle this in your own practice. And one of the key take-homes I have with any course like this, fine, we can sit down and chat about these problems, but if we simply converse about the problems and we don't make any action, if we don't have any progress afterwards, then really, what's the benefit of doing this? So you're taking time to actually go through this material. You might learn some things, but what I'm most concerned with is that following the class, that you sit down and say, okay, how can I make sure these things don't happen in my business? Or if they were to happen in my business, what can I do that would help me to deal with the ethical dilemmas that are presented here? So the thing that I generally suggest, the thing that I think is most beneficial, is some sort of policies and procedures handbook. Now, everybody who's watching this should already have some sort of a policies and procedures handbook, assuming you're active in the industry in the business of delivering financial advice. It's almost certain that you fall under FINTRAC regulation. And if you do fall under FINTRAC regulation, one of the things that FINTRAC audits is, do you have a written policy for dealing with money laundering? So I'm going to suggest you should already have a policy for dealing with money laundering, and that might be something you get from your mutual funds dealer or your managing general agency or from the insurer that sponsors your license, wherever you happen to get that document from, that handling of your money laundering responsibilities or your anti-money laundering responsibilities. You should have that document in place somewhere. That should be sort of page one of your policies and procedures manual. So at the end of the class here, ideally, you sit down and say, well, what's missing now from my policies and procedures manual? Is there something I can add to it based on the scenarios that we've gone through here? So I hope that gives you a spur to action. I hope that it causes you to think about how you can actually use some of what we're going to see here in your practice. On that note, we'll move on to the next section. Hi, and welcome back to the Business Career College video series. In this video, which is the second of a 5-part series, we're going to have a look at a particular scenario. So you should only be watching this video if you already watched part 1, which was the introduction to the ethics case studies. So in this particular scenario, and you can read through it, and obviously you should, you can pause for a moment if that helps you. So we've got a CFP professional here, Al. He's got a couple, Virginia and Brent. They are basically a joint engagement with Al. He's been working with Virginia and Brent as a couple. Now, Al happens to be insurance and investment licensed, and he deals with both Virginia and Brent's full block of business. Virginia and Brent are getting a divorce, so presumably they've gone through a period of separation. Now, acknowledging some realities of divorce law here, what should happen is at the date of separation, Brent and Virginia should have some sort of recorded documentation of the value of each of their assets or all of their assets, and that's what should get used. It doesn't always work quite this cleanly. That's what should get used to divide up any matrimonial property at that point. As the financial planner in this case, someplace that you can exert some positive influence here is when you become aware of the prospect of separation for Virginia and Brent, that you can make sure that they know that they should be setting a date of separation. Ideally, they agree upon a date of separation. That's not your job to have them agree upon that date, but just to make sure that they're aware that that's something they should do, and then they can actually kind of lock in the values as of that date. It's a good best practice here as their financial planner, and it can help to reduce fights that come out down the road. In fact, it might be one of the things that could have been done here that might have prevented the problems that we're going to see that follow. So now Brent tells Al, his financial planner, that he'll be moving, and this is where obviously Brent should be making sure that all this information is properly dealt with across all of Al's files. So Brent gives Al a call and says, hey, moving out here, change of address, and what ideally happens here is that Al makes sure that all client documentation is changed accordingly. And he does this by passing this on to Neil. So Neil is not maybe all there at the time when this happens. We see Neil is dealing with an illness in the family, and he just doesn't get around to this for whatever reason. Now, what happens now? Al, again, probably a good idea, finds out clients are divorcing, and he says, I should probably sit down with them and schedule separate meetings with them over the coming month. Now, something that you would have seen in our Addressing Conflicts of Interest course is a little discussion around whether it's appropriate for Al to continue to deal with both clients. And this is, again, something that I hope Al or you would have in your in your policies and procedures handbook, is some sort of discussion around how you deal with divorcing clients. Do you continue to deal with both of them? Do you pass one of them off to another planner? Do you allow the client to decide or the clients to decide? Do you have some sort of questionnaire you go through with them that would help them to make a decision? Which is it? And any of those can be, at least in my opinion, correct. Certainly, there's different degrees of risk aversion to each of those answers. If you're the most risk averse, if you want to make sure this is never going to cause you a problem, then what you're probably going to do is always find somebody to deal with one of the two clients post-separation or post-divorce. if you're willing to take on a little bit more risk, then you might be in the frame of mind where you say, I'm still comfortable dealing with both of them. And then you just have to make sure that you handle the client files, obviously, as two completely separate engagements and that no information ever gets shared back and forth across them. Now, in this particular case, Brent gives Al's office a call and says, I do have to do a redemption here. It's time for me to get some money out of a particular fund. And Brent gets that money out. Unfortunately, Al's office, as we see in red here, sends the confirmation to the wrong address. They send it to Virginia's home. Now, is there any harm done here? Well, let's have a look. So what happens now, first off, Brent does find out about this. It really shouldn't matter from our perspective whether Brent finds out or not. Once Al identifies that there's been harm, he should treat this the same way really in either case. So it's not necessarily the fact that Brent finds out that's the problem, it's the fact that this even happened that I would suggest anyways is the problem. So now Virginia says, well, sure, I opened it, I got documentation from your office, I'm used to getting documentation from your office. It wouldn't be uncharacteristic for you to send me something. I didn't notice the name on it. Now you might question Virginia's approach to this. You might say, well, Virginia should have paid more attention. You might even doubt whether Virginia's being honest or not, as I've heard some students speculate. But it doesn't really matter. Whether Virginia did something wrong or not doesn't change what happened out of Al's office. So now Brent is upset. And I think we can appreciate this. Whether there's any harm done or not, Brent is going through a divorce. It's generally an emotionally trying experience. He may not be overly tolerant of sort of a casual approach to mistakes. He may feel that this might jeopardize Al's ability to continue to handle his information in a confidential basis. There might actually be some harm done here to Brent, and this is a potentially bigger question, but is it possible that this allows Virginia to see that Brent has maybe some assets that are tucked away somewhere that she wasn't aware of? Now, Brent might be breaking some rules as far as disclosure of assets in a separation or divorce. Again, not really your business until you're told by the authorities, by appropriate legal documentation or appropriate legal authorities, that you're supposed to release this information. So if you're aware of some attempt by Brent to hide something away or something like that, certainly the Financial Planning Standards Council says you're not supposed to do business with Brent, but that doesn't necessarily mean that it's your obligation to notify Virginia of this either. So it might not even be anything so painful like that. It might not be that Brent's engaged in illegal activity or immoral activity. It might simply be that Brent is spending money in a place that Virginia doesn't agree with, and this might sour things as far as how they're addressing division of property, for example. So it might be something related to the kids that Virginia doesn't agree with, and this might give Virginia some ammunition to argue a position a certain way. It doesn't have to be anything so wrong as Brent actually attempting to hide assets. So I hope now we have a reasonable handle on what's happening here. We'll go on to have a look at the problem and some possible handling of it in the next portion of the presentation. Hi, and welcome back to part 3 of the Business Career College video series, specifically in this case dealing with some ethics case studies. So in the previous video, we looked at the dilemma that arises when Brent has some information released to his ex-spouse, to Virginia. So we already talked a little bit about the concept of harm. I would suggest that beyond the potential harm to Brent, there is definitely harm done here to Al and to his business. So definitely Brent is going to have good cause to question whether or not Al is capable of dealing with his affairs in a confidential matter, and it's quite likely that Virginia also has the same question. So even if we can't positively identify harm that comes about for Brent, we certainly have harm that comes about for Al. Now, it is possible, and this is very much dependent on the province you're in, that this might be a breach of confidentiality under privacy legislation. That does vary from province to province. You should know the privacy legislation that applies in your own jurisdiction. And it's possible that there could be fines associated with the improper disclosure of information. Now, is there any harm done here? Does this activity cause any harm? We've investigated that pretty thoroughly. The next question, does it matter if there's harm done or not? Well, for the purposes of our ethics discussion, it really does not. If we say, well, there's no harm done, so we're not really that concerned about it, that really sets up an environment in which down the road, you could have the same kind of thing happen, and then there could be harm done. And if we look at a pattern then and we say, well, we let 3 of these events slide because there was no significant harm, and then we get to number 4 causes real harm, well, that's where it's going to be pretty easy to show that Al wasn't running a very good practice in terms of protecting his clients, and it wouldn't be, I would suggest, very difficult for those clients to pursue Al for any losses that they might encounter. So we know we want to tackle this issue. We don't want to let mistakes like this go by, because even if there's no harm done here, this is very easily the kind of thing that could point to a mistake down the road. So some of the things that we could see here. Al apologizes to Brent and Virginia. I would suggest that this is something that should happen. I think most parties would agree that this is a fairly easy step to take. Has to be a meaningful apology. So I would suggest an in-person or at least a telephone call apology to Brent and Virginia, and in a way that shows that Al is actually contrite, that he actually is sorry for his actions. So to say, Brent, I'm sorry that I released your confidential information to Virginia. I understand that that might cause you some harm and that it might cause some harm to our relationship. Something like that. And the same thing with Virginia. Now, Al might say, okay, Brent, Virginia, I understand that this sours our relationship. I'm prepared to pass you over to a different person. So I'll provide an introduction to somebody else. That'll give you a reset on the relationship. This might be necessary. It might be that Al is going to lose these clients out of this arrangement. And if that's the case, it's probably best if Al manages that. And he might give that option as part of his dealings with Brent and Virginia. If he lets this relationship break and he doesn't do anything to help Brent and Virginia graduate to a new financial planner, there's some question about whether or not he has really taken meaningful action that would help Brent and Virginia. Is he looking out for himself, or is he looking out for his clients? He might pass both Brent and Virginia to might pass both of them to new financial planners, so it might be one, both, whatever it happens to be. Now, I'm not saying the next one is right. In fact, we're going to see in a couple slides that it's very specifically not right, but it does happen that Al might offer to make Brent whole as a result, in order to make up for whatever loss there is. So he might say, Brent, tell me what this cost you. I'll write you a check for that amount. That's not a good approach. It's probably not legal, but this is actually a fairly common thing when we see these kinds of problems. And something else that might happen here, Al may fire Neil, remembering that Neil is Al's assistant who didn't do a good job of following up with the change of address information. Whether Al can fire Neil or not under employment law is potentially a big question. Whether Al should fire Neil or not, I hope that one mistake is not sufficient, but if Neil's shown a repeated pattern of making mistakes and if he's always absent-minded, well, sometimes that's necessary, and if that's the case, fine. Whether Al decides to fire Neil or not, it's not something that he should be talking to Brent in Virginia about. And firing Neil doesn't make any difference as far as Al's level of responsibility here. Al ultimately is responsible for whatever happens. So if he says, I fired the person who did that, it's not my fault, that is not appropriate. Certainly the Financial Planning Standards Council says you have responsibility for your subordinates, and the same is true under most regulatory and licensing regimes. So simply trying to wash your hands of your responsibility here by firing the person responsible does not work. That's not an adequate solution. So what rules or guidance might we have that we can draw on here? Well, possibly we can look at the actual Financial Planning Standards Council, Standards Professional Responsibility. In fact, we will look at these in a couple of slides. Advocates often is a good tool for their best practices manual. If you happen to be an Advocates member, you can go have a look there. The Mutual Fund Dealers Association often provides guidance for these cases, although their guidance, and the same with IROC, tends to be very mechanical. They don't talk too much about things like maintaining client relationships or addressing errors, but you may have to deal with a set of rules that comes out of either MFDA or IROC if you happen to be part of one of those entities. The CLHIA doesn't give us too much here, the Canadian Life and Health Insurance Association, but they might provide some guidance here. There are some guidelines offered by CLHIA in terms of things like client confidentiality. So you might find some use there depending on which regulatory bodies you deal with. So then, under securities and insurance legislation, as I mentioned previously, you cannot simply write checks to clients to make up for losses or for mistakes. This is less clear under insurance law, but the concept is still there. And this is something that happens. It does happen occasionally that an advisor's been in business for 25 or 30 years, and they get caught out after that long, long career. And it turns out that for the last 10 or 15 years, they've been doing this regularly. They have a big successful practice, and it allows them to make a lot of mistakes. And then when a client catches them in a mistake, that they'll just write a check to the client quietly off to the side. That is not a good behavior. That simply means that you're not fixing your mistakes, that you're going to continue to basically steamroll over those mistakes and really ignore any actual harm that might be done to clients and to the industry and to your practice as well to go along with that. So I had promised that we'd have a look at the Financial Planning Standards Council, Standards of Professional Responsibility. Certainly Principle 6 confidentiality has been violated here. And then very explicitly, Rule of Conduct number 21, which we can see on the board here. And we can see that this reaches out not just to the financial planner, but to staff as well. And we can see the obligation to have a process in place, which is what I had mentioned in the first video. Again, I would like to reinforce that process. So what should happen here is when Al got word that there was a change in address, that Brent had a change in address, Al should have said, Neil, here's the information, and Neil should have had some sort of a reporting process that he had to follow in which that change of address was tracked properly. Now, that's not to say a mistake can't happen, but those processes should reduce the likelihood of mistakes. So ideally, some sort of a checklist or something like that that we can use to help us out with this. And then beyond that, this is not what this slide refers to in particular, but probably not a bad idea to have a process in place for what happens when we've had an inappropriate disclosure of information. Now, Al could say, I'm never going to have an inappropriate disclosure of information, but I don't think that that's necessarily a good assumption to make. So it can happen, and if you say, I'm never ever going to make a mistake, or I'm not capable of making mistakes, I really think that's a head in the sand approach to this. So you may or may not want some sort of a policy that says when a client's done wrong by us, or when some sort of harm has been done, or even something as specific as a breach of confidentiality, how do we respond to it? And around that standard professional responsibility then, so Al does not have necessarily responsibility to inform the Financial Planning Standards Council, although if he comes under regulatory action, then that might be the case. But just by a breach of confidentiality, he's not required to inform FPSC. I generally think this is best practice. I know some people are hesitant to do so for fear of what it might do to their ability to renew their designation or whatever the case is. But in my dealings with FPSC, it's better off to inform them of a problem and allow them to have some responsible time to address the issue, rather than letting them find out about a problem secondhand, and then they might be a little bit more reactive. And there might be shorter timelines, there might actually be harm done to a client, and they might have to respond a certain way. Now, who else might we or should we talk to? So first off, do not just try and brush this under the carpet. So we're not going to try and hide this. We're going to bring it out into the light and deal with it. So all interested parties, Brent and Virginia both, should be notified of this. Now, they both are aware already, but still, going back to the apology phone call, we probably should be having some attempt to talk to them about this, and to the extent that it's possible, to tell them how you would prevent this from happening in the future, or what action has been taken around this. Don't push this onto the back burner, deal with it right away. Now, I know, again, that people are going to be hesitant to take the next step, but I would suggest it's often beneficial to reach out to your errors and omissions insurer. And the reason for this is because nobody will have seen more of these things than the E&O insurer. And that doesn't mean you're submitting a claim. You can call your E&O insurer, you can say, hey, have you seen this situation happen? What have you seen in terms of outcomes here? What do you have for useful advice? And none of those things are claims. And again, in my experience, E&O carriers are generally very receptive to this, and they will have seen more of this than anybody else. A similar approach holds to Al's managing general agent and to his securities dealer. So whatever supervisors Al has, whoever is responsible for Al's business, he may have a contractual obligation to inform them of this, but at the very least, he should inform them so that they have the opportunity to provide some input or feedback for Al. If this isn't a common occurrence, they probably won't be too worried about it. They should be appropriately worried, but we're not looking at, from one instance like this, most likely not a terminable offense or anything like that. If it is a terminable offense, Al, is better to deal with it sooner rather than later anyways. And then what's going to happen is now all involved parties are going to exercise mitigation, and it has to be recognized that Al could have negative consequences here. I had mentioned previously that under privacy legislation, there may be a fine or some such levied against Al. There may be some sort of disciplinary action. That's the consequence of Al's activities here. So you do something wrong, it can have negative consequences. It's that simple. So it's not fair to say that letting everybody know isn't going to have any negative outcomes here. There could be negative outcomes. And if there happen to be fines or penalties levied, Al's E&O carrier may or may not get involved. Generally speaking, errors and omissions insurance policies do not pay fines or damages. They will, do not pay fines, I apologize. They do not pay regulatory fines. Damages they generally will pay. Sometimes they won't if it's related to an illegal activity. So Al might want to check the wording of his errors and omissions insurance policy here as well, and you should be aware of what's covered under your E&O policy at the same time. So I hope that the Brent and Virginia case, helps you to recognize how confidentiality and client mistakes could possibly be handled. We'll wrap this case up here, and in the next video, in part 4 of this series, we'll move on to another case. Thank you very much, and enjoy your continued studies. Hi, and welcome back to the Business Career College video series. This video is part 4 of the Ethics and Professional Responsibilities Case Studies course. So you should have watched the other 3 parts already. You should have already dealt with the Brent, Al, and Virginia scenario. And now we have a different scenario here. So now we've got Linda, CFP professional here. Amanda is a client of Linda's. And Cynthia is Amanda's enduring power of attorney. Amanda does not have capacity, which would have triggered the power of attorney. So now Cynthia is acting in the capacity of attorney for Amanda. And since this happened about 1.5 years ago, everything has gone relatively well. Cynthia is not otherwise a client of Linda's. And there are a couple of things that we should recognize about powers of attorney. So under a power of attorney, Cynthia is a fiduciary to her mother. So Cynthia has the legal responsibility to take her mother's best interests to heart. And power of attorney legislation does differ a little bit from province to province. So there can be some differences, but where we're going to stay here is with just basic principles. However, you may need to become familiar or talk to somebody who is familiar with power of attorney legislation for your particular jurisdiction. And as always, this course is not intended as legal advice. If you need legal advice, you go find that legal advice from an appropriately qualified legal professional. So we've got power of attorney in place then. And we've seen basically over that last 1.5 years, Cynthia just taking out the regular RIF withdrawals to meet Amanda's RIF requirements, and everything seems to go well with Canada Pension Plan and Old Age Security. And that's perfectly fine. This is what we would expect from a power of attorney. Nothing unusual here. Now, what we have to recognize is who is the client here. So even though it will be Cynthia who is Cynthia who is making the decisions. She's making the decisions for Amanda. So it really is Amanda who is the client. And that's an important distinction with powers of attorney. Everything has to be done for Amanda, okay? And we can see from the will that Cynthia is the sole beneficiary of Amanda's estate, and she's also the primary beneficiary on Amanda's RIF. So basically, Cynthia is going to get whatever is left when Amanda dies. So this very morning, Cynthia called Linda, our financial planner, and went through the circumstances. So Nick is unemployed. Nick is Cynthia's job, or Nick lost his job. Nick is Cynthia's husband. And Cynthia's been unemployed for a long time, and she's got some medical complications. So now she's concerned about her mortgage. She's been told by her financial institution that foreclosure proceedings will start next week if they can't make their payment. Nick's out of EI, and they just don't have any money available. Nick went and got himself a job, doesn't make much money, and his car broke down, and now he can't make any money at all from that job. So if they go into foreclosure, they're going to have to move away. They're going to have to move in with Nick's parents, and nobody will be able to provide care for Amanda. And this would provide the substantiation, at least in Cynthia's mind, for why it's okay to dip into funds for somebody other than Amanda. So there is no other power of attorney. There's nobody else that we've ever spoken to with respect to Amanda's case. It's just Cynthia and Amanda. There's not another power of attorney named somewhere. There's not other siblings that have been regularly a part of this process or anything like that. So Cynthia says, I'm coming to see you this afternoon. We're going to do a redemption request. We're going to pull an extra $10,000 out of Mom's RIF. Now, this would be okay if this had been happening regularly. If Amanda was in the habit of giving $10,000 a year, for example, to Cynthia to support her, a power of attorney is designed to allow gifts like this to continue in the nature that they originally started in. That's not what's happening here, though. This will be an uncharacteristic withdrawal. So, when you have this kind of thing arise, just step back for a second here and say, all right, who is the client? Now, you do have a legal responsibility to do as Cynthia asks. Okay, that is absolutely the case, that Linda has to do what Cynthia asks, but there are some things that we have to consider around this. So if there was no power of attorney in place, if it was still Linda and Amanda dealing with each other directly, and Linda's been Amanda's financial planner for a number of years. She helped her to build out a retirement plan. She's responsible largely for the financial plan that they're working on. She did all the projections and so forth, and she knows what Amanda's normal set of expenses are. And now Amanda calls Linda and says, I want to take an extra $10,000 out. Well, I'm sure any financial advisor, financial planner, or otherwise at this step would say, hang on a second here, what's going on? And would step back from that and ask some questions and make sure that Amanda understands what's happening. And I have seen this work, actually. I've seen where with the power of attorney, it's simply just a matter of stepping back and asking a bunch of questions. So just like Linda would do if she were dealing directly with Amanda, she now steps back and says, okay, Cynthia, do you understand the consequences of this withdrawal? Do you understand what this does to your mom's long-term retirement plan? Do you understand what this does to your mom's income projections going forward? Do you understand this is going to cause an adjustment to the financial plan? And what she should probably do at the same time is ask about power of attorney legislation as well. And power of attorney legislation is actually pretty clear on this matter, that it is not legal for the attorney to take actions to enrich themselves. So we know that, but that doesn't necessarily mean that we can do anything about it. It's one of these issues where legislation might exist, but enforcement of that legislation can be a substantial problem. Now, if it's a clear-cut case of elder abuse, you may have an elder abuse hotline that you can call for advice here or something like that. It may not be a clear-cut case of elder abuse, and this is where you can't go to Amanda either. Amanda has lost capacity. She is not in a position to make any decisions. So she is not going to provide a good resource for us to deal with either. So we can see where this gets to be a fairly difficult scenario. There's not really an easy outcome. And I will caution you right now that ultimately, if push comes to shove, there is probably nothing that ultimately can be done to prevent Cynthia from taking this money out. There are some things we can do along the way. We have to be cautious about those things, and we'll see that in the next video. So I hope we're well established now for the Cynthia, Linda, and Amanda scenario, and we're going to delve into some of the outcomes and possible handling of this situation in the next video. So thank you very much, and do enjoy your continued studies. Okay, welcome to the fifth and final video in the Business Career College video series dealing with ethics case studies. You should have watched part 4 now concerning Cynthia and Amanda. So we went over some of this at the end of the last video. So we know now Cynthia is intending to withdraw funds from her mother's accounts. These accounts are for Amanda's use. And this is why this money is sitting there. So this is something that gently, or maybe forcefully, it depends on how you do business and what your relationship with Cynthia is like, but we have to deal with what Cynthia is trying to do here. It's important here that you not pull out an accusation of theft or fraud or something like that. Accusations of that nature can do more harm than good, and it may not be an accurate representation of what's happening. It's not really up to you to make such an indication, but I think it's important at the same time that Cynthia recognizes what her responsibility here is and how she can best fill that responsibility. Certainly, I've seen where planners or advisors in a case like this resisted, found ways to put up little roadblocks or made it obvious to Cynthia that they weren't going to make this easy. And subsequently, Cynthia would go to another financial institution that would be a little bit more lenient and would move those funds over to the other institution so that withdrawals could be made without a fuss. And certainly you'll see that kind of thing done. I don't think that's a reason not to resist this. I think that the threat of moving an account or something like that, fine, are you better off without this account? And I would suggest that just from a business management perspective, if you continue to deal with powers of attorney who are clearly not acting in the grantor's best interests, that probably poses a lot of risk for your business. So fine, if there's other institutions that are willing to treat basically Cynthia as the person who can do whatever they want and they won't put up any resistance or any roadblocks, well, losing that client might not be the worst thing. And I understand that that can affect compensation and so forth, and you might justify it otherwise by saying, well, any tiny little bit of positive influence that I can exert is better than what I know will happen in another institution that won't do anything positive at all. But I think that's a pretty tenuous argument, and you really have to watch how much of your business do you want built on those relationships where you know there's something improper happening. So some of the things that we could do here. Well, it's possible that Linda could just say, fine, have at her, come in this afternoon, sign the paperwork, no big deal. And as I mentioned previously, that's probably what's going to have to happen here, unless Linda can really get things going in a very good direction, can recognize Cynthia, or get Cynthia to recognize what she's really doing here. So she can just shut down the office and go home early. I don't think this is a good approach. It's one that I have run into periodically, where you say, yeah, that client's too difficult to deal with. I'm just going to go golfing or something like that. It's kind of a half-joking solution here. I really and legitimately have seen people take this approach to problematic dealings with clients. This probably creates more problems long-term than it solves. It might fix the problem in the very short term, but I would question as to whether this is the approach we want to use to solving problems. The police, honestly, a police force is probably not going to want to get involved with this. Even if this is a clear-cut case of elder abuse, it's one that police forces have a really tough time with. They have to have a fair bit of evidence in order to charge somebody criminally. They really can't do anything to prevent activities in most cases. That being said, I have run into police officers here and there that might be able to help in less sort of difficult ways, maybe a quick phone call to somebody to remind them that they have seen elder abuse cases like this. I do think that it's actually worth cultivating contacts in the financial crimes or economic crimes units at your local police forces. Most big municipal police forces today have economic crimes or financial crimes division, and they tend to deal with abuses, usually more rampant than this, usually the kind of thing you'd see in a wide-scale investment scam or something like that. But they still might be a useful resource here. So the next one, tell Cynthia she can't make this withdrawal. This would probably be a flagrant violation of either MFDA or IROC or possibly insurance rules, that basically you're telling the legal representative of the account that she can't access that account. That probably doesn't fly. Certainly, I think you should explain to Cynthia her obligations as an attorney. And this is where I want to go back now to our discussion earlier around policies and procedures. So it's probably too late at this point, but this is where I would encourage you to develop a policy or procedure around not what happens when you have a power of attorney who comes to you and wants to do something inappropriate, although I'll show you in a minute that that's another policy you can develop, but rather that when you have Cynthia come to you in the very, very first place and say, I'm taking over for my mom, that here you can have a policy that says, okay, Cynthia, that's fine. We're going to go through the things that I have seen as problems in power of attorney relationships. So managing expectations here might be important. And it's possible, I know it's not a fail-safe, but it's possible that if a year and a half ago, when Cynthia originally executed the power of attorney, that if Linda had spoken to her then and said, here's what I expect in power of attorney relationships, here are some of the things that are legal considerations that have to be dealt with by the both of us, maybe, no guarantees, maybe that this might have been enough to head off a future problem. And I would suggest that if you did that when that initially happened, and then you do that as part of your regular KYC meetings, because Linda should still be meeting with Cynthia periodically to review the financial plan, to update KYC information and so forth. So Linda can go back to that power of attorney relationship every time she sits down again with Cynthia and review that. And that might put Cynthia in a better position to handle herself as the power of attorney. Now, I don't think in this case, in fact, in this case, I've deliberately written the case to indicate that there are no other responsible parties. It's rare that you would have this where there are other people that Linda could reach out to, at least within sort of Cynthia and Amanda's family. This would most likely be a serious breach of confidentiality. So unless there was something in the power of attorney document or otherwise that indicated this, probably reaching out to a family member would not be appropriate here. Like I said, probably a serious breach of confidentiality. So we saw this last time. We have different places that we might look to get some guidance on this. And the one that I'll add here that we didn't talk about last time was bankruptcy legislation. We already covered off power of attorney legislation, but bankruptcy legislation might give us a little bit of help here. And this is where maybe this is a tenuous argument, but you might make this argument with Cynthia, where we say, okay, Cynthia, do you know that if you draw on these funds right now, and then subsequently you and Nick have to declare bankruptcy, those funds are entirely forfeit, and that will reduce your inheritance, and that money will go to your creditors. And it's not always the case that bankruptcy and foreclosure are linked. Totally understand that, but it's likely that they're in this sort of downward slide, and bankruptcy is possibly on the horizon. Whereas, if she leaves the money in her mother's account, in Amanda's account, and simply doesn't touch it, well, now it's a bankruptcy protected asset, at least as far as Cynthia is concerned. So if Cynthia declares bankruptcy, the money that she's power of attorney for is not something that comes into this discussion. Whereas if she starts to pull money out, then we have a problem. Because now those creditors can come after those funds, and that really does reduce her future inheritance. So maybe if you can get her to engage in a little bit of long-term thinking about her future inheritance, that might be enough to swing things in your favor. So as always, we have a look at the Financial Planning Standards Council, Standards of Professional Responsibility. So Rule 1 under the Standards of Professional Responsibility does give us a rough idea here. It says you cannot deal with somebody who's engaged in dishonest, fraudulent, deceitful, or misrepresentative behavior. And I do think in this case, that's what Cynthia's doing. So not much else from FPSC about acting under a power of attorney, and really there doesn't have to be, because the power of attorney already legally provides all the mechanism we need. We know that that just makes that person responsible for the grantor's affairs. So if we decide that Cynthia is in fact engaged in deceitful or fraudulent behavior or something like that, well, can Linda really refuse to do business with her? This is where we have kind of two conflicting areas of law. We have the law that says the power of attorney has to have authority to sign this, and then FPSC says, yeah, but you're not supposed to deal with this person. Now, FPSC does say that where the law and the standards of professional responsibility don't match up nicely, that your first obligation, no surprise, is to the law. Again, from Advocates, the best practices manual, at least as of right now, late 2016, does provide a description of the power of attorney, but no particular guidance on dealing with the attorney in question. Again, no particular guidance from MFDA, IROC, or the Canadian Life and Health Insurance Association. Now, we might get a little bit of help here from power of attorney legislation. So, power of attorney legislation, if we can get Cynthia to at least acknowledge that this is something that she has to pay attention to, maybe this is enough for us. So power of attorney legislation says we can't make a gratuitous gift that is just a gift to the attorney unless a judge specifies that it's permitted. So maybe what you can do here is you can get Cynthia to actually go through this process. And you might have a lawyer who's even willing to do this on a pro bono basis. Again, developing relationships with some folks in the legal community can be very helpful here. So maybe you can get a lawyer to help Cynthia do an application up to get an emergency withdrawal from the funds. It's possible. I'm not an expert in this area, but the law does allow a judge to give permission to take these funds out. So maybe if Cynthia can build a case that says, if I don't take this money out, then we're going to have problems where my mom's not going to have anybody local to care for her, and then the consequences would be much more dire. She's probably not going to get what she wants exactly, but this is something that might be available to them. So maybe we can use the law to our advantage here without having to kind of wield the heavy hand of the law. So that wraps up the presentation on the two different ethics cases. I hope that you've got some ideas now about developing out a set of processes and procedures, adding to your existing book of processes and procedures. I hope that you've thought about maybe some of the things you've dealt with in your practice, and maybe this gives you an idea about how to deal with these problems should you ever have a breach of confidentiality or difficult dealings with powers of attorney. Again, both of these things are things that I've seen in regular client or in regular financial planner and financial advisor businesses. So I'd like to thank you very much for your attention today. You will have to have done the 5 quizzes. There will be 5 2-question quizzes to go along with this. And with the completion of those quizzes, then you'll be able to get your CE certificate, and you'll have met your obligations as far as the ability to renew whatever licensing it is you're renewing, unless, of course, you're in a jurisdiction like Saskatchewan, which requires more credits than 1 ethics credit every year, or whatever the case is. So I hope that that you've enjoyed this. I hope you found some value in it. If you have questions or comments, or if you have experiences to share around this or anything of that nature, I'd love to hear from you. My email address right here on the screen, jason@businesscareercollege.com. And again, I'd like to thank you very much for your attention, and please do enjoy your continued studies.